Yeah,
Yes.
in respect of item number 7, madam, your lordship kind enough to call up-to-date case diary. So,
Received or not received? My lord, the receiver not up to date, my lord. One report from my lord, Maharashtra, my lord,
it's
is
required.
not received.
Required.
My lord,
What,
is the my lord one dentist, my lord, graduated from my lord one
Maharashtra
dental college
Dental
from
College.
Maharashtra, my lord. That are you on interim?
My lord. So it is actually
Okay,
required from
Mr. B. Sharma learned additional PP submits that he has received the case, but the same has not been updated. Accordingly, it is provided that Mr. Sharma shall produce the updated case diary before this court on
7.
well, till then, interim order pass earlier shall continue.
It is interim then on 18.
the.
18 all better, my lord, because it will come
Let
from
it come
Maharashtra,
from
my lord.
Maharashtra, let
18.
it-
Yes, okay, my
18
lord.
June. On 18 June.
My lord. Yes,
No, my lord, let it be on 20th, 19 June, madam,
19.
or 21 June, madam. I
Okay,
think.
all right.
Because Eid is there, madam, 21st of June.
21.
21,
24.
21st.
For motion bail application, item number 9.
Material was for the previous about a charge sheet and last we came before lordship earlier. Your lordship directed
So this is second bill application.
second bit of earlier.
So what is the
material was-
ground?
Now you are directed to expedite the hearing and within 3 months, not a single witness will till today. My
What is SARS has been framed.
charge frame that time also your lordship also not charged. At that time charge also framed.
So when the first application was rejected by this court,
Your lordship order is page 43, 12 to 24.
43,
Page 43.
12,
12 to 24. And last part your lordship order is last page 47. Operative part. It is not recovered from his possession. On the basis of co-accused statement, CDR, because the CDR your lordship rejected that time, giving an my observation that expeditious hearing with paragraph within 3 months. That is page 47, paragraph 20 and 21.
but Mr. Soruri, in the case of Bar Association, Allahabad High Court versus State of UP, Supreme Court has said that no time frame can be
No, I am not by the
fixed.
my right is also your lordship knows because so many cases are there on Supreme Court. 21 is also at the same time. State interest as well individual balance to be struck. Now your lost kindness is not a single witness as an example. All are officials, madam. How long it will go? Madam?
Yes, Mr. Locker.
Lordship. Lordship, and that is to Lordship, but Lordship, that judgment is it's specifically stated, Lordship, that is a 4 bench judges judgment, Lordship. It is specifically stated, Lordship, that time frame should not be there, Lordship, and
No, preferably it is
no,
at least
it
something
is-
ought to have been done. That is why I'm
it is
saying.
not written, it is written like
Then
that,
your
Lordship.
lordship say
No,
for the line.
only in exceptional circumstances.
Lordship.
Is there any exceptional
Madam,
circumstance in your case?
Maybe because nothing was removed from possession on the basis of co-accused statement, madam.
No, that was already
So that is
considered.
also prima facie matter. I am not saying that matter actually is a case of acquittal, but on the face of it, that it appears.
Okay, let the status report and the scan copy of the record come from the lower court.
Short date minus status.
Okay. Let's shall call for the scan copy of the record and up to date status report fixing the matter of COVID.
Case number, special NDPS case number.
Okay,
Yes.
you will do.
Yes,
7 June.
7th June. 7th of June.
yes, I may be represented by someone, I do not know my.
No problem. No problem. Anyone can represent you.
Obliged.
Yeah.
Obliged to your lordship.
For bail hearing, item 1.
My status report or scanned copy of the,
Yes, both.
that may be, madam.
Yes.
Yes, obliged.
Item 1, bail hearing.
May I please, your Lordship? But yes, last order, I had seen the High Court bars in Allahabad judgment, but the reasonable court, there the hindrance there cannot for extension of the period, my lord, it is barred, my lord. So my humble submission, my lord, with heavy hearts, my lord, since I am failed to convince this honorable court under section 37(2), I made an additional affidavit that said that even all my belongings, landed property, all these things, to get the trust of this court, my lord, I ready to surrender in that since I'm failed to satisfy your lordship under such circumstances, so I have, my lord, I want to withdraw, my lord, since I'm failed, my lord, to convince your lordship under section 37, my lord. I
Then what to do?
my
You
302,
suggest the court.
that, today is the 302, 302
Days.
days, I'm in the custody, my lord, and though I am doing business, then even I'm ready to surrender all my certificates, land belonging, Aadhaar card, PAN card, everything, my lord, even day to day, daily basis, I want to present before the court in
No,
court.
Mr. Dekka, be
So-
logical.
So, my lord, if this court not satisfy
Uh-huh.
of my submission or my additional affidavit, so I am to withdraw, my lord, otherwise I'm no option.
Mm.
It is up to your lordship, my lord.
So the problem is that we cannot direct the trial court also. You complete the trial within such and such period. Unless
Because of this judgment,
exceptional
my lord, I understand, my
circumstance
lord.
is shown.
So, my lord, out of this, out 9 witnesses, 3 witnesses will examine, and nothing materials against me, my lord, from independent witness, my
So
lord,
maybe, but the other witnesses are yet to be examined.
yet to be
And
examined, my lord.
as suggested by him, the other witnesses have implicated you.
This honorable court even cannot direct the expedite the process as far as this order, my lord. So, under such circumstances, my lord, their destiny,
Okay, we'll see and pass the order. Okay.
obliged.
Item two.
May I please, your lordship?
CD receipt, lordship.
Here, your lordship will get the FIR.
You were behind the bar for how many days?
Your lordship, 28 days, your lordship.
28 days. Yes.
FIR is at page 14, your lordship.
So I have remembered it on the other day, perhaps you have submitted.
Lordship. What has happened, your lordship, in
Allegation.
that case, your
But the
lordship?
problem is that the informant is perhaps a retired police officer.
Lordship, that's
With all his earnings, he purchased a plot of land.
lordship.
So this person's
No, the problem is created by the owner of the land, your lordship. He executed 2 power of attorneys, one in my favor, your lordship, one in favor of the person who sold it to informant, your lordship. Now, your lordship, I executed an agreement with accused number 2, who was already granted bail, your lordship. Accused number 2. Now, accused number 2 filed your lordship, title suit, praying for your lordship. Page 42, your lordship will get, your lordship, the title suit, your lordship. That is also pending, your lordship, for specific performance of the contract, your lordship. There is an order of status quo also, your lordship, in that
title suit.
title suit, your lordship.
Yeah, so what is the stage of investigation?
Some evidences has been collected, lordship.
Collected. So whether further custodial detention is required in the interest of investigation?
Okay, leave it to lordship.
Pardon?
Already, so some witnesses has been collected, lordship, and the statement of the accused has also been recorded, lordship. And he has also stated, lordship, that he has occupied 10 acres of land. He instructed the main accused person to occupy that 10 acres of land, lordship.
That
And
you were-
the main accused person also stated, lordship, that this person,
So
this
one of
accused person-
the co-accused has already been enlarged on bail.
Bail.
Where is that ordered?
That page 64, your lordship.
By trial court.
By time. It discusses the operation, your lordship.
So this is first application or second application?
This is first, your lordship.
Are you sure?
Yes, your lordship. So far as my instruction, your lordship. On the basis of instruction. Yeah, go to the High Court of Foreign.
There is all accused person has been arrested, lordship.
Both of them were arrested.
Salim
Three.
was, no? All 3.
So relevant documents have been collected and all the accused persons have been arrested. heard Mr. S. Borthakur, learned company for the accused, and also heard Mr. T. S. Lakur, learned additional PP for the state respondent. This application under section 439 services prepared by accused Izazul Haq, who has been languishing in Jailazut in connection with Satgao PS case number 20 of 2024 under section 420, 468, 471, 384, 506, 34 APC for grant of bail. The above noted case has been registered on the basis of an FIR lodged by one Tamizuddin Ahmed on 7/2/2024. The essence of allegation made in the FIR dated so and so is that one Ibrahim Ali and Ijazul Haq and Hafiz Ali have illegally occupied a plot of land
Yes, it is.
measuring 10 laces covered by DAG number 2157, patta number 1236, situated at Satgao Village under Beltola Moza of Dispur Revenue Circle, belonging to the informant Tamizuddin Ahmed and Riaz Ali. By obtaining forged land documents. And they also demanded money from the informant for vacating the occupied plot of land. And also threatened the informant with dire consequences. Mr. Borthakur, learned counsel for the accused, submits that the accused was arrested on
4-5.
4/5/2024. And for last 28 days, he has been languishing in jail as and that one of the co-accused has already been arrested and released on bail by the learned additional session judge number 2 in BA number 204 of 2024, white order dated 30/3/2024. And that the accused is no way involved with the offense alleged in the FIR, and in fact, it is the owner of the vehicle, owner of the land, who has given two power of attorney, one to the accused
Lordship, one to
and
the-
the other to
one Selim Ali, your lordship.
one Selim Ali. And that the accused is ready to cooperate with the investigating agency and therefore it is contemplated to allow the petition. Whereas Mr. Locker, learned additional PP, has produced the case before this court and fairly submits that all the accused of this case has already been arrested and relevant documents have already been collected. However, Mr. Locker submits that the IO has collected some materials in support of the allegation made in the FIR. And therefore, Mr. Locker has opposed the petition. Therefore, is having heard. The case diary indicates that all the accused persons here in this case have already been arrested. And relevant documents have already been collected and seized by the IO. And further, it appears from the page number 64 of Annexure Z of the petition that one of the co-accused has already been enlarged on bail by the learned additional session judge number 2, Kamrup M. Guwahati. And further, it appears from the case diary that the IO has achieved substantial progress in the investigation of the case. Under the above facts and circumstances, further custodial detention of the accused, in the interest of investigation seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 year like amount with the satisfaction of the learned CJ Kamrup M, the accused being enlarged on bail. Case will be returned. the floor.
Item 3,
Also here in this case, up to the CD not received. Lordship. He is an interim lordship.
When interim was granted,
Lordship,
Yes,
he-
yes. Lordship, interim was granted.
when
Lordship on
on 22/12/23 probably.
Mr.
Lordship.
P.S. Lokur learned additional PP submits that he has not received the case diary. Up to date case diary. Accordingly, it is provided that Mr. Lokur shall produce the up to date case diary before this court on
On 10th of
till then interim order passed on 22/12/2023 shall continue.
public.
items 4 and 5. My lord, in is charge sheeted, my lord. Charge sheet file number,
Yeah,
my lord.
acha. When?
My lord, on my lord 34/24, my lord.
30/4/2024.
My lord.
Search it number
Charge sheet number 53, my lord.
53 of 2024.
My lord.
Under section
Under section, my lord, in the all the section mentioned in the FIR, my lord.
acha.
They are all on interim, my lord. Item number 4, 5, and 6, all are on interim.
Identical.
Yes, arising out
Same
of the same
FIR.
FIR. 4, 5, and 6,
Okay.
all are on interim.
Heard Mr. S. Das, learned counsel for the applicant, and Mr. B. Sharma, learned additional PP for the state respondent. This application under section 438 CRPC is referred by. How many applicants are there?
My lord, in the first item, my lord.
7.
7.
Seven applicants, namely Habibul Islam alias Bapi, Hasanur Islam Bakur Ali, Abu Sama Nur Haq Zoirul Islam, and Surman Ali. For grant of fee respect. किसको बोलो नहीं? It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Dr. Mujibur Rahman. Of Ambari village. On 5th of January 2024. The essence of allegation made in the FIR dated. Whether any person was granted bail earlier?
No. All are on interim bail, man. Interim bail granted.
The essence of allegation made in the FIR dated so and so is that on 5th of January 2024, at about 12 noon, while he was proceeding towards towards Assamese Department of South Salmara College. After attending BA second semester class, then one Surman Ali, Nur Haq Bapi, Bakur Ali, Abdul Awal, Abu Sama, Hasanur Rahman, Nur Islam, and Sahidul Islam, and some others. Entered into the college compound all of a sudden and dressed him and assaulted him, and also rebuked him with abusive words. Mr. Das, learned counsel for the applicant submits that the applicants were granted the privilege of previous bail by this court by order dated 22/2/2024 and pursuant to the said order. All the applicants have appeared before the IO and cooperating with the investigating agency. Therefore, Mr. Das contended to make the interim order dated 22/2/2024 absolute in the same terms and conditions. Whereas Mr. Sharma, learned additional PP, submits that he has not received the case diary, but as per his instruction, the IO has completed investigation and submitted search sheet being search sheet number 53 of 2024 under section so and so on 30/4/2024. In view of the submission of learned advocates of both the parties, this court is inclined to dispose of this application by directing the applicants to appear before the learned trial court on or before
20 June.
and to apply for regular bail. And in the event of filing such an application, the applicants, the learned trial court shall consider the same in accordance with law. Till then, interim order dated 22/2/2024 stands extended. Same order in 5, 4, 5 and 6.
6.
Surman Ali.
Okay, 6.
Item number 8.
Highly officed.
Item 8.
Well, this is an interlocutory application which I have filed for vacating that stay order, my lord, which was passed, my lord, earlier. Right, my lord, order dated 6/11/2023, my lord.
Yes, what is the ground?
The ground which I have stated here, my lord, is that, my lord, even a reading of the FIR, my lord, that reflects that there is a prima facie case, my lord. And at this stage of the investigation, because, my lord, that ought not to have been stayed just because family members are involved, because here the question of defrauding the banks are also involved, my lord. Initially, what happened was, my lord, one of the brothers, my lord, he wanted to take a, my lord, loan, my lord, by way of, my lord, mortgaging the entire, my lord, parental properties. There, my lord, we had given a no objection for that purpose, but subsequently, my lord, what happened is, on that loan, my lord, the loan was initially issued by one bank, then it was again transferred to a different bank. It was taken over by a different bank. And after taking over by the different bank, another loan was applied for that is called a top-up loan, my lord. In that top-up loan, my lord, my signatures were not obtained, and without obtaining my signatures and without my permission and consent, my lord, my signatures were forced, my lord, put by somebody else, my lord. And my lord, thereby, I was also encumbered into the loan. And it happened not once, but twice, my lord. And thereafter, my lord, I had to file this FIR, my lord, just to save myself, my lord. Now, the question before your lordships is, my lord, at this stage of the investigation, I am being told, my lord, that even, my lord, these signatures have been sent to the forensic science laboratory, my lord. So, my lord, a report may be called for from the forensic science laboratory or from the IO, my lord, as to what does the forensic science laboratory, my lord, examination discloses, my lord. If it discloses, my lord, that there is a, my lord, falsification of signatures and forgery of signature, definitely an offense is made out, my lord. And if an offense is made out, my lord, the prime, my lord, case, which has been, my lord, projected by the petitioners before these lordships, is that, my lord, it's a family matter and a civil dispute. But my lordships is aware, my lord, even if it is civil dispute, my lord, if criminal elements are there, my lord,
No,
then
that
there is
may
no
be,
part.
but only the primary consideration before the court
Yes,
was
my
the
lord.
family
Yes,
matter.
my lord. Whether, my lord, the FIR discloses an offense or not. If the FIR discloses an offense, my lord, and thereafter, my lord, a reading of
This
the.
is only interim order, we can
Yes.
vacate it any point of
Yes,
time.
man. That is what, that is my prayer, my lord. That is my prayer. It may be vacated, my lord, and the investigation may be directed to be continued because, my lord.
So, Mr. Soudhuri,
My
you
lord.
see, just because family members are involved in
My
the case,
My lord.
only that consideration we have stated.
I understood, my lord. I understand that, my
So
lord.
is there any settlement between the parties?
No, my lord.
My lord,
There is
that
no
is,
settlement.
that is just the half of the story. The allegations put by them is that the said loan were taken without his consent, my lord. But that is not true. He himself has been paying the EMIs of that particular loan since 2020. And my lord, before the trial court, he has admitted this fact that this, and he has volunteered himself to take over this loan in 2020. And prior to 2020, also he has been paying the EMIs. My lord, now the question is, why has he filed this FIR at the later stage after 6 years on his mother? Because, my lord, the mother has initiated domestic violence proceedings before the trial court, and he is prejudiced by that proceedings. This FIR is a counterblast of that proceedings because the interim order has went against him, my lord. He has himself has been paying the EMIs since 2020. This is, I have annexed the document, document number, the annexion number 3, my lord, of the written, of the writ petition. Over there, he has admitted it is his document, not mine. He's stating, my lord, that he has been paying the EMIs since 2020. Now, my lord, he is in 2022, December, he has filed this FIR. Prima facie, my lord, this FIR is a false, and none of the ingredients, my lord, is present in the FIR also to proceed with the investigation.
My lord, who will determine whether it is right or wrong, my lord? Can, my lord, a submission made by a council determine, my lord, whether it is right or wrong? And, my lord, the fact that I have been paying the EMIs, why I have been,
Okay, Mr. Soudhuri, let us do one thing.
my lord.
The additional, who is for the state? Mr. Sharma, are you appearing in this case? As a criminal petition.
We have not made party, my lord.
No, made party.
State is a party.
And even kindly see, my lord, the police commissioner has also made a party in that, my lord, in that petition, my lord. Registered as a writ petition criminal, my lord, kindly see, my lord. Don't understand, my lord, how petitions are being filed. Respondent number 3, kindly see the commissioner of police has made a party in this, my lord. What has he got to do here? Simply dragging a, my lord, officer here before this court.
Yes, Mr. Sharma?
Yes, my lord.
Perhaps the file is not there because it
Yes,
is,
my lord. File is
my
not
lord,
with us,
it
my
is
lord,
represented by the principal secretary home. It must have gone to the WPC department, not with the, my lord.
Additional PP.
I have to ensure, my lord.
Eh?
I have to ensure, my lord.
So GA Assam is here reflected.
Yes, my lord. GA Assam is.
GA Assam is not the
Please,
PP.
then only our copies are upon us. If,
Inform the GA
then that we can.
right now, if possible.
How much is it?
If available, ask someone to come here. Dinner appeared. Inform dinner.
Dhanesh appear করেছিল নি? directly this petition could have been registered as a criminal petition. Now, what happened is it was registered, my lord, power was invoked under 226 as well as 482, my lord.
That provision is there under Article 226 is also there. For the quashment of the FIR.
Yes, provision is there. Yeah, heard Mr. Z. Sotore, learned counsel for the applicant. Mr. You were Ising.
Yes.
Ising, learned counsel for the respondent number 1. Respondent struck opposite party number 1. None appears for the respondent opposite. Dean Dipankar Nath. Dipankar Nath.
Dinathi Dipankar Nath. Oh, yes, yes, sorry.
Nothing. Mr. Sodhuri, learned counsel for the applicant submits that this interlocutory application is preferred for vacation of the order dated 6/11/2023 passed in the WPC within bracket criminal number 37 of 2023. Whereby investigation of the Dispur PS case number 2536 of 2022 under section 419, 420, 468, 471, 34 IPC was stayed. Mr. Sodhuri further submits that. Yes, madam, are you appearing in this case?
Lordship, in this matter, senior government advocate Dina was appearing. He was on legs.
Where?
Yes, sir.
But,
He's coming, he's in some other court.
Lordship,
can we record your presence?
Lordship, you can.
What is your name?
B. Dekar.
B. Dekar. Junior government advocate. Further submits that here in this case, sample of handwriting of the present applicant has already been taken by the investigating officer and sent to the FSL. And as such, the respondent number 2, the state respondent may be asked to produce the said handwriting, said report of the handwriting expert before this court on next date. Yes?
My lord, that is, even if the FSL report states that there is a possibility of that the signature is forged, that is, my lord, that is a assumption. On its own, FSL report cannot form, my lord, the basis or a conclusion.
First let the report come. Thereafter we will hear you.
Right.
It is not that on the basis of that report we will immediately vacate the stay order.
Right.
Having heard the submission of learned advocate for both sides, it is provided that Ms. Dekar, learned junior government advocate, shall produce the case diary of Dispur PS case number 2536 of 2022 along with the FSL report. FSL report or handwriting expert?
FSL report.
FSL report.
FSL report. I mean, examining the handwritings.
FSL report before this court on next date. Rest shall list the matter on when? Suggested date?
15th of June, my lord.
15.
15th.
Yes, madam, possible.
15th Saturday on 14th.
14th of
14.
14th.
Okay.
14th.
My lord, the interim order maybe.
Till then, interim order plus earlier shall continue. Right?